if you actually read the case where this protection order was granted, this was just the permission to proceed under pseudonym for the plaintiff. It had nothing to do with protecting witness identity. So the citation is bad, and they miscited it, but whatever. Yeah, but anyway, so they wanted to basically keep it sealed now. This is the proposed order for the judge to sign, basically. Was still there in person? Yeah, they were. Plaintiff's motion for extension of time to file response, reply, answer as to the opposition. Okay, so we filed a response to their order to compel Kiwi Farms to remove videos because it's just, everything about it is ridiculous. You're not going to ask them to remove any of my videos, literally just for your client. You're not even going to ask for other women's videos to be taken down. You're just literally it's inappropriate. Kiwi Farms isn't a party to the case. You can't issue a court order compelling a non-party to do something, and the requesting of attorney's fees as a result of it is stupid. A court order to remove something doesn't prevent it from being reposted in the future. It's just dumb. But they filed this for an extension of time. Unfortunately, there was no response, or fortunately, I guess, but they didn't get a response to the court, so they still had to file this. But this is the transcript being available for order. And then the judge decided to, the judge will seal the order until he gets, makes a ruling on it, basically. So they've temporarily granted the order to seal while he decides on what he wants to do, which isn't completely ridiculous. It would be kind of pointless to seal something after it's been made public for a while. So we just have to wait for him to, I guess, figure out what he wants to do with it. It could also be that he's just waiting to rule on this whole preliminary injunction, because the ruling on that might influence his decision here, maybe. So it is temporarily sealed right now. I have to wait for him to decide on it, which is pretty annoying, I guess, because Jane Doe has had no problem posting a whole bunch of This is what I like about court, okay? This is what I like about court. When we go to talk to the judge, and when we go to talk in filings, this stuff has to be put here under penalty of perjury. So we really have to mean what we say, and we have to say what we mean. Jane Doe has had the opportunity to say a whole bunch of wild and crazy shit about me on her fucking Substack. Fuck, what was this? Oh, this. Somewhere? Wait, what am I looking for? This. So she had the opportunity to say a whole bunch of crazy shit out here publicly. This is all public, by the way. Without any of this being under penalty of perjury, without being in front of a court. And then now when I finally get my day in a hearing to ask questions and respond and to give my perspective on things, they've demanded for that to be sealed and hidden from the public, despite the fact that her side of the not under oath statements remaining public, which is ridiculous, but whatever. It's not whatever, it's actually gross, and it's a fucking abuse of this system, but okay. Let's see, response and opposition to motion for protective order. These are our filings. Oh, and this is just us arguing against these protective orders are just stupid. For why they're trying to file, like you can't, like filing protective orders for every single witness. This is just not normal. It's not the ordinary case of things. Again, if you look at like all the Cardi cases that have been filed, none of the ones that I've read, the witnesses aren't protected names. The witnesses' names are just there because it's part of the case. But whatever. Declaration from my lawyer about the emails and the trying to set up meet and confers. Just the emails from this other lawyer are just fucking, just so stupid. But whatever. Joanne is just very special. Let's speak at 1 p.m. EST. Andrew, as discussed, on our, she said that. Discussed on a meeting for May 12th, attached to a draft and proposed confidentiality agreement and protective order regarding discovery. This draft are confidential, which means it is not to be made public or shared on social media by anyone, including specifically your client. Please advise we would like to move forward with a joint stipulated agreement. We're open to suggestion edits. Thanks. And then she says, based on your non-response, we consider our meet and confer efforts to have reached a resolution on a joint protective order to be exhausted. Joanne, it's 10 a.m. I marked up your proposed agreement and will send you our comments when I get out of my meeting. I think she mixed her time zones up because she said, let's speak at 1 p.m. EST. And then she said here, maybe Andrew mixed his time zones up. Oh, wait. Oh, no, I see what happened. She says, following up on this, please let us know defendant's position by noon tomorrow. But she didn't specify a time zone here. So she must have assumed it was EST, and I guess Andrew assumed it was PST. And so she emailed at this, I'm guessing this is from Andrew's, so it's probably 1:10 her time, saying that you didn't respond, and they said it's 10 a.m. I marked up your proposal, let's go back. Yeah. I like the whole, like, if you're 10 minutes late though, she's like, non-responsive. And they want like a day to, like, Jesus, chill, but whatever. Fun, good times. Funny memes. Joanne says, although witness identities are not inherently confidential in many cases, in a Cardi case where the defendant is publicly streaming and doxing, like this is just not a word you use in court. A name is not doxing for purposes of like a court case. And witness intimidation and harassment are real and ongoing concerns. Yeah, welcome to the internet. You don't think I get intimidated and harassed? If I direct any, well then sanction me for it. At this point, you should be praying for me to be intimidating and harassing targets because it's the only out you have in any of this, you know? Exhibit 2 has some funny markups for their dog shit filing. Wait, hold on. I'll go back and check. There are strong legal and equitable grounds for protective order that includes the confidentiality of witness identities. I cannot think of any legitimate reason that your client would be opposed to keeping certain witnesses' identities confidential. We will proceed with filing a motion. The interest is a public interest. You don't get to make, again, if you want to release like Substacks and if you want to release Twitter or Twitlongers, or if you want to do like other things like that, then fine, go for it. But if you want to take me to court and you want to make me waste all this money and you want to sue me for big boy dollars, then we'll go through the court process. But that process has things attached to it, like the credibility of witnesses, like people's names being attached to things. Like they've been allowed to outsource the entirety of their legal prep work to the internet, which is evidenced by the fact that they're copying Kiwi Farm's arguments for all other stuff. And so I have a right to have people that are accusing me or working as witnesses in this case to be made public. This is not like a drug dealer assassination ring where your people are going to be murdered or whatever. Like, it's so stupid. The default is that the names are public and you need to provide a very compelling reason to make them private. Exhibit B had some funny markings. Wait, fuck, what? Oh, this is a lot. Oh, is this our redlining? The name or identifying information of non-party witnesses who wish to keep their identity private. They want to seal and keep anonymous every single potential person to come forward. This is bullshit. This is bullshit. And then other confidential information, the disclosure which is likely to cause injury to the producing party. Like, this is all of this is. In accordance with Illinois law. Nice, boilerplate. They didn't change the state. Good meme. Scroll up, he marked up a typo. Yeah, I saw that. Why do they want to do this, Destiny, other than protecting the identities of people? Well, something that I have personal knowledge of is Pixie and other people, Gisticle, are like desperately reaching out to every person. It's like the Mr. Girl shit, reaching out to every person I've ever talked to, saying like, hey, we can keep all of your information private. Like, can you please like come and testify or say that like he lied about this? Like, they were asking one person, one girl that I've been friends with, like, can you please come and testify as to like whether or not Steven has like ever told you that like we've ever hooked up before or stuff like. It's just like, it's just ridiculously stupid shit. They're just like, they're grasping at so many straws to try to keep this case alive and to survive summary judgment, which I'm pretty sure is against, I don't know if it's a federal rule of civil procedure, but you're not allowed to just enter random bullshit so that you survive summary judgment, which is what they're really trying to do. The interesting part, in my humble opinion, is that the part they submitted in Section 80 is a completely different document. Oh, I didn't really look at that. I do know, I don't know if I said this, or not, but they sent an order to us, the order that they were going to send to kiwi farms